Now, without going into the details of the case, and I also hope that when there are questions and answers, nobody will ask me to go back to the details of that case. I don't want to revisit that case. My main challenge was to find plausible points to argue, to engage the attention of the court. After all, we were not just going through the motions that yes, he had to be given a lawyer. The Supreme Court has done its bit by giving him a senior counsel, and so you say whatever and then leave it to the court. That wasn't the idea. And as a senior counsel, I felt I needed to present something plausible, something which the court would consider. And in spite of the fact that it was an open and shut case as far as the evidence was concerned, we did find a few points to urge. One, lack of fair trial by invoking the Miranda principle, that a foreign national had to be told his rights under the Indian Constitution. Mere offer of legal aid at the time of arrest wasn't enough. Also, that very little time had been given to the lawyer in the trial court, Mr. Kazmi, to prepare the case. He had asked for 4 weeks' time to prepare, and he was given only 8 days. And out of those 8 days also, 3 days he was kept engaged in arguing the question of whether he was a juvenile or not. And so I think it was possible to make a strong argument on lack of fair opportunity because enough time was not given. As a matter of fact, as a counsel, I feel rewarded and happy that on this question of right to counsel, the court in its judgment gave directions for the future to the magistrates that they had a duty to inform the accused that they have a right to a lawyer and that they would be given legal aid if they couldn't afford a lawyer, and that failure on the part of the magistrate to give this information, basic knowledge, to an accused would lead to disciplinary action against a magistrate. Secondly, on the voluntariness of the confession, there was scope for considerable argument, and this was again an argument which the court considered very seriously. Of course, all my contentions were rejected, but this is again a contention which engaged the attention of the court. Then the argument on waging war, because Kasab had been sentenced to death under 5 heads, one of which was waging war against the government of India. The High Court found that the waging of war was the most aggravating circumstance which made him deserve the death penalty. I also felt that out of 5 capital charges, if even one could be reduced, then the balancing of aggravating and mitigating circumstances would be affected, because it would then be 4 and not 5. And there was again scope here for a very plausible argument that with the amendments to the Unlawful Activities Prevention Act, what Kasab was accused of was a terrorist offense, and that the very offense of waging war was now ocious or irrelevant on principles akin to implied repeal. In making this argument on it not being, the offense did not amount to waging war, I was able to make use of observations in the High Court judgment. Reliance was being placed on the Parliament attack case and the Red Fort attack case. These were seen as symbols of the Indian state, and therefore attack on those amounted to waging war against the Indian state. The High Court said the Chhatrapati Shivaji terminus is a public building. I tried to argue that there was a clear difference between a railway terminus and either the Parliament House or the Red Fort, from which the Prime Minister gives his address every year. Those are surely symbols of the Indian state, but certainly not a railway terminus. I must also tell you as an aside, this Chhatrapati Shivaji terminus, apart from being a railway station, is also the headquarters of the Central Railway. I come from a railway family. My father had his office there when he was posted in Bombay. My grandfather had his office there when he was posted in Bombay. And so when I was arguing this case, this thought was also present in my mind, that the attack was conducted in a building with which my family has been connected in some way or the other. And then, of course, there was scope for advancing a powerful argument on the question of sentence. Here was a young man of 21 from an underprivileged background, brainwashed by an extremist ideology. Surely the fact that he was so young and was brainwashed in these circumstances, he went into their lap because of his family background, was an important factor in not giving him the death penalty. Again, here I could make use of some clumsy observations in the trial court judgment. The trial court said, while awarding death sentence, that we do not want another Kandahar. So my argument was that pragmatic considerations can never weigh with a sentencing court, and the sentencing court has to apply sentencing principles which for Indian courts have been adequately laid down by our Supreme Court. Arguments concluded in May 2012. 29th August came the judgment, and you all know what the judgment was. Gopal and I addressed the media together. I said, I bow to the verdict of the court. Let us take pride in a judicial system which gives a hearing to the most dreaded accused. I think the Indian judicial system did itself proud. Now, I felt that after the judgment was pronounced, my role as amicus ended. Others haven't felt so. It was no part of my duty, I felt, to advise the filing of a review petition, because I felt that an amicus curiae appointed by the court is to argue the case on the basis of the record before the court and made available to him, and nothing further. On 23rd of October, the Ministry of Home Affairs recommended to the President the mercy petition, which had been filed because he had received advice to file a mercy petition, which was filed. The mercy petition was rejected by the President on 5th November 2012, and Kasab was hanged in Pune on 21st November 2012. Now, as I said, I have faced criticism. I am reading out to you comments which appeared in Frontline, which devoted an issue to the Kasab case after the judgment. I am happy that my friend Dr. Venkatesan, a legal scholar and a deputy editor with Frontline, is here, and it is his criticism which I am referring to here. He asked me, did I ever feel the need to meet Kasab? I said no. I said I'm arguing his appeal in the Supreme Court on the basis of the record. This is not a trial where I need to advise someone on how to face cross-examination, how to strategize. This was not relevant at all at the Supreme Court stage and not part of my duty as amicus curiae. Mr. Venkatesan asks, here the key question to ask is whether the failure to meet Kasab hindered Ramachandran's ability to argue on his behalf. Another question was put to me on the question of sentence, whether Kasab had feelings of remorse or not. How would the court be told unless you met him? To which my answer was, neither the High Court nor the Supreme Court takes evidence either on the facts of the case or on the state of the mind of the accused. The appellate court's view or even the trial court's view on the question of sentence, of which remorse is but one aspect, has to be based on the evidence on record. A counsel's impression based on an interview is quite irrelevant. In fact, if such an impression is to be taken into account, a counsel would become a witness. The Supreme Court's view on remorse or lack of it was based on the record to which its attention was drawn. But is Ramachandran also not duty-bound to help Kasab draft his mercy petition to the President after the dismissal of his appeal by the Supreme Court? The fact that he did not help Kasab in this matter is curious. His response to Frontline was as follows. Here again, the advice of the amicus could have been sought through queries to the registrar, but this was obviously not considered necessary. This option was obviously made known to him in jail itself, as I am sure it is to others on death row. I must also tell you that I have faced similar criticism about my role as amicus in the Gulbarg case. Manoj Mehta has written a book, The Fiction of Fact-Finding. He says, for someone, and he said something nice, who had been a law officer for the Vajpayee government, Ramachandran displayed remarkable independence as amicus curiae in standing up to the SIT's resolve to exonerate Modi of all charges. At the same time, his scrutiny seemed to have been hampered by the fact that he never really stepped out of the frame set by the SIT. Ramachandran's literal interpretation of his brief might have enhanced the credibility of his reports, but in the process he seemed to have overlooked some material evidence. This was in the context of Manoj Mehta's view that I should have asked the SIT why it did not put certain questions to Modi and others, while I saw my role strictly in terms of the order appointing me amicus, which said the amicus curiae will give his independent assessment of the material on record. Now the problem here is this, and I am concluding. There is no textbook from which an amicus can learn what he should do, what he should not do. It is ultimately the amicus's own perception of what his mandate is. I hope this will provoke a discussion. Thank you all for your patience.